Before we even step into this courtroom, let's set the stage. This is a child support modification case where numbers, agreements, and expectations are about to collide. Mr. Hernandez believed he had a deal in place from his divorce, a modest $150 per month in support. But now, the state is stepping in, applying Texas Family Code guidelines, and suddenly that amount jumps dramatically. We're talking insurance credits, guideline calculations, and a ruling that could reshape this father's finances overnight. Stay with me, because what starts as paperwork quickly turns into a high-stakes legal reality check, and you'll want to see how this judge breaks it all down.
The parties have reached a partial agreement, Your Honor. They have agreed that Mr. Hernandez gross monthly income is $4,300.27. He has no other children, Your Honor, and he has agreed, the parties have agreed that he will carry health insurance, excuse me, for the children at $105 per month and dental insurance at $7 per month. Your Honor, they have I believe that is the agreement, Your Honor.
They have agreed what?
Do you need me to repeat that? I'm sorry.
No, I got cash medical 105, dental 7. Gross monthly is 4,326. I didn't hear anything after that.
It's yes, gross monthly $4,327. Mr. Hernandez will carry the health and dental at those costs per month.
Okay.
And I believe that is what the parties have agreed to. The rest of it is contested.
Right here is where things get serious. The court establishes Mr. Hernandez's gross monthly income at about $4,327 and confirms he'll carry health and dental insurance for the children. That may sound routine, but this is the foundation for everything that follows. In Texas, child support is heavily driven by income, and once that number is locked in, the guideline formula does the rest. Notice how the judge immediately focuses on specifics, medical, dental, and cash medical support, because these details directly affect the final monthly obligation. Let me ask you, if you thought you had a private agreement with your ex, would you expect the court to override it this way?
All right. You may proceed then.
Okay, thank you, Your Honor. The state asked the court to take judicial notice of the prior order in this case. It's a final decree of divorce, and it was signed 2/7 of 2024. Your Honor, it set child support at $150 per month with a step down of $116.66. It doesn't order any one person to carry dental or carry health insurance, I'm sorry. And it does not set a medical support payment. So I'm going to call Mr. Hernandez.
Okay.
Mr. Hernandez, what is your full name?
Renee Senon Hernandez.
And so so it's presumed reasonable to apply the guidelines to calculate child support. So once you have the credit for the health insurance and the dental insurance that you're carrying, guideline child support calculates out to be $881 per month. And then it would step down to $705 per month. And that $881 would begin 3/1/26. Are you in agreement to calculating support based on the guidelines?
I'm sorry, but you keep cutting it off.
Okay, I'm not sure what. Okay, it's presumed reasonable to calculate child support based on guidelines that are provided in the family code. And in this case, based on your income and giving credit for you paying for the health insurance and dental insurance, child support based on the guidelines calculates out to be $881. And that would be per month, beginning 3/1/26 with a step down once your oldest child emancipates to $705 per month. are you in agreement to the calculations for child support based on the guidelines provided in the family code?
And there it is. Mr. Hernandez officially says no to the guideline calculation. This is a huge moment. He's explaining that during the divorce, both parents agreed to $150 per month because they were actively involved with the kids and didn't want money to drive the relationship. That sounds reasonable on a personal level, but legally, verbal agreements don't carry much weight unless the court formally approves them. This is where many parents get caught off guard. The judge explains that Texas law presumes guideline support is in the children's best interest, and overcoming that presumption requires substantial evidence, not just a past conversation. Do you think personal agreements should matter more than state guidelines?
No, ma'am.
Why
And
is
why?
that, Mr. Hernandez?
Because during our divorce order, one of the last subjects touched on was the child support amount. And me and Miss Rodriguez both agreed to sign the divorce order with the amount being the $150 per month, since we are both highly active with the children and we didn't want to base any money difference on the divorce. And that was a big reason to signing the divorce order, was on that agreement with the child support.
All right, let me look at the divorce decree. Because what happens, Mr. Hernandez, is you can agree to set child support at a certain amount that's not in accordance with the Texas Family Code. It's what we call contractual child support. However, it has to be approved by the court. You can't just agree to that without getting approval of the court. And so sometimes this divorce decrees, the divorce judges do mention that it should stay at that amount. So let me look at your divorce decree. What she was talking about is that there is a presumption in the family code that the guidelines that we have to follow, which would set your child support at 881, there's a presumption that that's in the best interest of your two children. And that in order for you to not have the court not follow that guideline amount, you have to overcome the presumption with substantial evidence. So let me, just to make sure we double check everything, let me look at your divorce decree. I'm getting it from your court file to see if maybe the judge ordered that it shall remain. Okay, so let me look at that. What was the date of the divorce decree?
February 7th of 2024, it was signed.
And that's the other thing, Mr. Hernandez, these orders are checked every 3 years. They're checked every 3 years. And there has to be a difference in the child support amount by $100. In other words, your income has to amount in a change in the child support amount by more than $100. So, but your divorce decree was just recently. It's under the 3 years. However, there can be a substantial change. You can also petition the court to change the child support amount because there's a substantial change in the party's circumstances. So Miss Shavasa, because it's under 3, remember the family code allows you to do it if it's more than 3 years and the child support amount is more than $100 in difference. And
Yes,
it
Your
is, in his case, it's 105. No, the child support is 881, but in his divorce decree it was 150. So it is more than $100, but it's not 3 years.
Yes, Your Honor.
Unless you all are pleading the substantial change. Is that
Your
what
Honor.
you all are?
No, Your Honor. We filed a modification. We're able to do that under the family code at any time when there's an issue with the health insurance. And so the divorce did not set a medical support payment
Got it.
Here, the judge carefully walks through the family code rules. Child support orders are typically reviewed every 3 years, unless there's a substantial change in circumstances. Even though the divorce is recent, the state can still seek modification because medical support wasn't addressed in the original decree. That opens the door to recalculating everything. You'll also notice the judge reviewing the divorce paperwork live, confirming there's nothing locking support at $150. This is textbook courtroom reality. What's written in the order matters, not what was verbally agreed. It's a sobering reminder. If it's not in the decree, it might as well not exist.
And so we have an interest in addressing the health and dental.
Okay, I see that. All right, it says, it is ordered that Rene Hernandez is obligated and shall pay to Janelle $150 per month beginning February 1st, 2004, until the child reaches the age of 18, marries, dies, or becomes emancipated. Thereafter, when child support is to be paid for one child only, Rene Hernandez is ordered and shall pay to Janelle when 16. In other words, when the oldest child graduates. Mr. Hernandez, I don't see anything about it that the court ordered it should always stay at 150. I'm looking at it, unless you have your divorce decree and you want to point that out, but I don't see it, Mr. Hernandez.
I'm looking at it right now, man.
Okay. Sometimes I miss it because it's you're looking at it digitally.
No, ma'am, I don't.
No, I don't either. And so let me ask you a couple of questions. Mr. Hernandez, your gross monthly, she said, was $4,300. Your employment, does that stay the same amount every month, or does it vary because you make overtime or you don't make overtime, or is that pretty steady?
It's about the same every month.
Okay, and you don't have other children?
What was that?
You don't have any other children other than these two?
They're over 18. I still have one pending case with the child support, but she's over 18.
All right. And so is that your only reason for not wanting to pay the guideline amount, is that agreement that you might have had with her regarding the it being 150?
Yes.
All right. Ms. Rodriguez, you heard his testimony. He is objecting to setting child support at the guideline amount. He's stating that you all had an agreement at the time of the divorce. What were you requesting from the court?
What was I requesting today?
Yes.
Oh, I was requesting to get the guidelines, but I did mention, we did have that discussion with the lady before, and she said if I wanted to, we could make an agreement before we went before you, and I said I would be okay with 500, but he didn't agree, so she said that we would go with the guideline.
Okay. All right. Ms. Rodriguez, just to make sure, he's indicated that at the time of the divorce, you all apparently had an agreement, and it was probably verbal because it's not in the court order, but do you recall signing any kind of contract that would leave the child support at 150?
No.
Now we hear from Ms. Rodriguez, and this changes the dynamic. She admits there was no signed agreement to keep support at $150, and she reveals she was willing to settle for $500, but Mr. Hernandez didn't agree, so the case defaults back to guideline support. This is a classic crossroads moment. Once negotiations fail, the court steps in and applies the formula. The judge makes it clear, without strong evidence to justify deviating from guidelines, she's leaning towards the higher amount. This is where strategy matters. Compromise earlier or risk the full guideline ruling. What would you have done here? Accept $500 or roll the dice with the judge?
Okay. All right, Mr. Hernandez, I've reviewed the decree. It does not order that the child support will stay at 150. And because there's a substantial amount in the child support of 105 for 2 children, it's kind of hard for me to approve it. However, she's indicated she is in agreement with 500. What is your response to that, Mr. Hernandez?
If that's the lowest I could go, then I'm willing to do that.
No, I can decide
Yeah.
if you want to, but generally speaking, the guideline amount is something that we follow unless there's a presumption to overcome that. And you've testified that the only reason is because of this conversation you might have had with her. So I'll ask you again, do you have a response before I rule? She's indicated 500 is okay.
Um,
And you don't have to. I mean, it's just something she stated. Better yet, we'll just leave it like that. Ms. Shovasa, did you have anything else, Ms. Shovasa?
Yes, Your Honor, I do need to question the parties on non-disclosure and court costs.
Okay, you may proceed.
Thank you. Mr. Hernandez, do you have any safety concerns with your information being included in the order?
no, ma'am.
So your information will be included in the order. Um, and court costs. So we can ask the court to order that. In this case, it would be you, the non-custodial parent. We can ask the court to order you to pay the court costs. I just need yes or no whether you agree to that or not.
I initially didn't, but it's fine. I'll pay the court costs. I just need to know how to.
That'll be a different department, Mr. Hernandez. I would wait till you get an invoice from the district clerk. Okay?
Okay. Yeah, I just don't want to get in trouble for that.
Department. Yeah, it's not our department. We don't know how much it is. They do their own invoicing, or I don't know how they collect. So just let them send you an invoice. And then once
Beyond child support, we now see additional layers: court costs, non-disclosure requests, and safety concerns. Mr. Hernandez agrees to pay court costs, and Ms. Rodriguez asks for privacy protections, citing verbal conflict and wanting her address kept out of the order. The judge balances both sides by allowing non-disclosure except for email and confirming public pickup locations for the children. This part often gets overlooked, but it's critical. These orders shape how parents communicate and exchange custody going forward. Family court isn't just about money, it's about structure, boundaries, and preventing future conflict.
they do, there'll be a number on there where you can work a payment plan or something.
Okay. Yes, ma'am.
Okay.
Mr. Hernandez, are you in agreement to allow Ms. Rodriguez to have a non-disclosure finding in the order? And that would keep her information out of the order. And it would keep it from you as well.
The only concern I had was about the geological restriction in order to make sure we complied with that restriction.
Would you be in agreement to a non-disclosure finding for her if her email was included in the order? Only her email address only.
I don't mind her. Well, it was more about the address. Just
Okay.
My boys are older, so I do drop them off at their house once in a while. I just don't want it to be used against me.
If she were to move or
Where
something.
do they pick up? Where do you pick up the children, Mr. Hernandez? Where's your pickup and drop off place?
At Pico's gas station
Okay,
in
so
town,
you all,
or
Okay.
at the school.
all right, then there's no reason for the questioning on the non-disclosure, Ms. Shovasa. If the pickup and the drop off, the court order gives them a public place, then that'll be fine.
Okay, may I question Ms. Rodriguez?
On what, non-disclosure?
Yes, Your Honor.
Yes, you may proceed.
Thank you. Miss Rodriguez, what is your full name?
Janelle Rodriguez.
And are you what safety concern do you have safety concerns with your information being included in the order?
Yeah, he does know where I live, but I prefer him to stay away from my residence. I have told my boys that I don't want him being dropped off there. That's why in our visitation rate, the boys go to school Friday. Their dad picks them up Friday after school, and he drops them off Monday at school, and I pick them up from school or after practice. And then on Thursdays, it was to where we meet at Pickles, but both my boys, they're all in sports. One's in 7th grade, one's a freshman. And some Thursdays, either they have game or they have practice. So usually they don't go with their dad, or if they do, he picks them up after their practice. So I prefer him not to be anywhere near my residence.
Okay, what are your concerns with him knowing your address, your information, including your address? If you were to move or
with him, it's a lot of verbal, like if he gets upset or anything, like he's real verbally violent, and I just prefer to stay away from that. And to be honest, I have not communicated with him personally since we've been divorced. If my children really need anything, they are old enough to communicate with their dad, and they do that.
okay, the law has changed to where it does require a party's email address to be in the order, unless the judge orders it to be excluded as well. So are you okay with your email address being in the order? I don't know what the judge
Yes.
is going to rule on it, but
Yes, with my email, it's fine.
your email is fine. Okay. And then as far as court costs, are you in agreement for Mr. Hernandez to pay the court costs?
Yes, ma'am.
Yeah, we'll pass the witness, Your Honor.
All right, based on the party's testimony, the court will grant child support modification pursuant to the Texas Family Code guidelines of $881 with a step down of $705 beginning February 1st. Cash medical will be $105 at a cost of $105 and dental of $7, also beginning September 1st. Court costs will be billed to Mr. Hernandez. The non-disclosure will remain in place other than emails. If either one of you wishes to appeal it, you've got 3 business days to do so. I am advising you that you do have the right to appeal it. As soon as the order is signed, you'll get something from the courthouse saying, I have signed it, and they'll give you the date. From that date, you count 3 business days and you file something, and it'll be sent to another judge if you wish to appeal it. That'll be the ruling of the court. You are excused.
Your
Thank
Honor.
you for coming to court.
Your Honor, may I? I'm sorry. I just need some clarification. So the child support 881 begins when?
I
2/1
said
or
February, well, we're February 1st, so it would have to be March 1st. You are correct, Ms. Shavasa. They'll have till March 1st.
okay.
The same with the court medical, the cash medical of $105 and dental.
And non-disclosure for Ms. Rodriguez,
Non-disclosure will be granted.
for Ms. Rodriguez only.
Sorry, can I make one clarification?
Yes,
They agreed to him carrying the insurance through his employer.
right. The
No
cost
cash medical.
is at $105 and the dental is at $7. What happens, Mr. Hernandez, is since you're providing insurance, they reduce the child support to give you credit because you are paying $105 for insurance and $7 for dental. And so they take it off of the top, and that's how they arrive at the 881, because they have to give you credit for what you're paying in insurance. Okay, that'll be
So
the
how
ruling of
much-
the court.
How much
Any
with
questions?
the child support?
Child support is 881.
And court costs, Your Honor?
So the
Ms. Shavasa, court costs will be billed to him, Ms. Shavasa.
Thank you.
Yes, Mr. Hernandez.
I was saying, so the 105 and the 10 and the $7 doesn't come off of the 181.
No, it already did when they were calculating it, because the insurance is going to be, Yesenia, through another source or through his employer?
Through his employer.
All right, so what's happening, Mr. Hernandez, is when we set child support, the law states that if you have it available through your place of employment, then the order is going to reflect that you are ordered to provide and continue to maintain and provide that insurance through your employer. And so you have told us that to insure the children, it costs you $105 a month and $7 for dental. So when they're calculating the child support, they take your gross of $4,300 And we set child support based on your take-home pay. So you start with your gross, you deduct the Social Security, the FICA, the Medicare. That's what you get deducted from your paycheck. And then they arrive at a net amount. And then on top of that, they're going to give you credit, and they deduct 105 and 7. And then that's when they start calculating for 2 children, because you don't have any other children. For 2 children, it's 25% of that amount. So you're already getting credit of 105 and 7. You don't have to pay it. I made it seem like maybe you were paying it every month. No, you don't have to pay it. Your only payment is $881.
Okay. And
Okay.
does the Attorney General's office send the note to my employer for the medical?
Yes, they will send, well, what they're going to do is they're going to send a wage withholding order so your employer can deduct $881 according to your paycheck. Like if you get paid once a week or every other week or twice a month. They don't get involved in the insurance because there's nothing to withhold. But Mr. Hernandez, the question that everybody asks is, people think that you've got to wait for the enrollment period. You know how they tell you you've got to enroll, if you want to enroll somebody in your insurance, it's like October or something like that. You don't need to wait for that date. All you have to do is provide them a copy of the order where it says that you are obligated to provide insurance through your place of employment. It's a court order, and so they'll enroll your children at any time. You don't have to wait for the grace period. I mean, the enrollment period.
Okay, just double check.
All right.
Yes.
Yeah, just give them the orders. You can hand deliver that to your, I guess it would be your human resources department or whoever takes care of the insurance enrollment. All right. Any other questions, Ms. Rodriguez?
Yes, well, whenever he does get the insurance, whenever I actually take the children to the doctor, how does that work? Or like, because I know, I guess with how personal insurance now? No, ma'am. He'll provide you with a little card. He'll get a card from his insurance, and then you just present that to the doctors. Okay. And like the copay or whatever I have to pay, I pay it, or how does that work? No, the insurance states that the order will state that anything that's not covered by insurance, it's your obligation 50-50 to pay for those medical bills. In other words, whatever insurances usually cover 80%, that other 20% that insurance doesn't pay, which would include copays and all that, each of you have to split that 50-50. Okay. All right. Then any other questions, Mr. Hernandez, that we can answer for you?
No.
All right, then you are excused. Thank you very much. Thank you. Bye-bye.
So, here's the final outcome. The court grants child support modification under Texas Family Code guidelines. Mr. Hernandez is ordered to pay $881 per month with a future step-down, plus cash medical support of $105 and dental of $7, though he receives credit for providing insurance through his employer. Court costs fall on him, and a limited non-disclosure order protects Ms. Rodriguez. The judge also explains exactly how the math works: gross income, deductions, insurance credits, and then the percentage for 2 children. This case is a powerful example of how quickly a $150 agreement can turn into an $881 obligation once the state applies guideline law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.